It's your time.
May it please the court, entering into appearance is Chima P, counsel for the plaintiff, representing 211 Faculty of Law, University of Benin. My lord, in this legal proceeding, I am not here alone. I am here with some learned co-counsel. First is Kefas T, and secondly is Adesola A. My lord, three of us shall be making representations on behalf of the plaintiff.
May this temple of justice remain pleased. D.R Sarumi is my name. Appearing with me are D. Lough. Lough is spelled L-O-U-G-H. Are you hearing me, my lord? Are you hearing me, my lord?
Yes. Yes. I can hear you.
Okay.
I can hear you.
Okay, thank you very much, my lord.
I can hear you.
We also have Atere. Atere. Atere is spelled A-T-E-R-E. Appearing with me also is A.P. Ganiju. A.P. Ganiju. Also appearing with me is A.M. Bashir. A.M. Bashir. Appearing with me also is R.A. Lawal. R.A. Lawal. We humbly announce our appearance as counsel to the defendant in this instant case. Thank you very much, my lord.
My lord, at this particular point, I think the plaintiff, what normally counsels will be appearing for the defendant, because the late counsel for the defendant called a lot of names before this honorable court. We are quite saddened, my lord.
Yeah, my lord, we have just only three counsels. We have just only three counsels that will be addressing the issues before the courts. All others are not. They are just announcing. We just announce their appearance, not that they will argue.
Okay, duly noted. Thank you.
All right. Can we proceed?
Yes, my lord, we could proceed. However, my lord, we have some preliminary issues to notify this court before the plaintiffs enter into their substantive arguments.
Go ahead.
Yes, my lord. First of all, the modalities for this particular competition says that each thing submits is brief 24 hours before the virtual session. However, we received the defendant's brief yesterday evening. It was less than 15 minutes, 15 hours, my lord. That is one of the issues we want this court to notify. And since this proceeding is based on markings and who has the higher mark wins, we want this court to deduct from the defendant's mark in respect of that late submission.
Objection, my lord. We need to understand what the counsels to the plaintiff are trying to insinuate. We do not understand them. We humbly ask this court to ask them to please explain themselves clearly.
Are you there?
Yes, my lord.
It appears
Yes, my lord, we may proceed.
All right. Can you make your objection very clear? Appears defense.
Yes, my lord. They are simply stating that the modalities for this competition, which is like the constitution that governs this constitution, just the way the constitution governs Nigeria, states that each team shall provide this brief 24 hours before the proceeding. My lord, we received the defendant's brief yesterday evening. It is less than 15 hours, my lord.
All right. I'm sure by now the understood the objection. So can you please address the court?
Thank you very much, Your Lordship. It is never in our habits to go against the clear-cut rules and regulations of the courts, and God forbid the day we will do that intentionally. Your Lordship, we tried all our best, but we could not make the submission on time due to some unforeseen circumstances, and it is a tried principle of the law that the law will never command impossibility. It was very impossible for us to make our submission at the required time. And apart from that, Your Lordship, it is a tried principle of law that issues of technicality should not be allowed to vindicate or overpower the substantive issue, Your Lordship. We hereby seek the indulgence of the courts, and we tender and we serve the apology to the courts and also the counsel to the plaintiff. And we hope Your Lordship will accept our apology without any fine, without any deduction from our mark. Thank you very much, Your Lordship.
All right. In order not to further, I have reviewed the objection by the plaintiff counsel. Even though in his objection, he did not make clear what his prayers were as to whether I should not hear the defense in this matter.
My lord.
In order to be able to proceed, I will overrule section.
As the court pleases.
Yeah.
As the court pleases.
My lord, further, there's something that we need this honorable court to notify. The defendant's brief that was submitted to the plaintiff for the stay of proceedings, it contained Benin Judicial Division. The memorandum of conditional appearance contained Benin Judicial Division. However, the heading that comes with their main substance contained Abuja Division. My lord, we are quite in the quagmire as to understand what the defendants are insinuating in this particular proceeding, because we do not quite understand why they'll be filing processes and using different courts division of the Federal High Court.
All right, counsel to the defendant. Are you there? Could you please address the court on that objection?
Your Lordship. First of all, I would like to cite the clear position of the law. By virtue of the provision of the Constitution, there is only one Federal High Court in Nigeria. And all other judicial divisions, they are also deemed to be Federal High Court. That is to say, we have just only one Federal High Court in Nigeria. This was the holding of the court also in the case of MKO Abiola against the FRN. Your Lordship, we are aware of the law that such mistakes should not in any way emanate from diligent counsel. But Your Lordship, perfection is meant for the Almighty God, and we are very sorry that such inadvertent error emanated from us. And we also pray that Your Lordship should not allow such mistake on the part of the counsel to overrule the substantive case, Your Lordship. Thank you very much, Your Lordship.
My lord, may the plaintiff have anointed before this court.
And I think the objection is fundamental.
My lord.
It is a law that you have just one Federal High Court in Nigeria. There are divisions. There are different divisions of the Federal High Court. And it is an unredeemable error. In fact, a different division in a process. But however, considering the You have to overrule the objection.
My lord, my lord, please, before you overrule, is it possible the plaintiff have an audience before this honorable court? Yes, my lord. Please, the defendants seem to be always raising the act of their mistake. From the first objection we raised as to late submission, they raised the issue of mistake. Now, secondly, they are raising the issue of mistake. My lord, this court can't keep giving them favors because of their mistake. So I'm not saying this matter should not be heard. The matter will be heard. We are very much aware that there's only one federal high court in Nigeria. However, we want their mark to be deducted. That's all the plaintiff seeks, my lord.
Exactly. I was making. Actually, I'm overruling the objection on the mere fact that we are going to proceed with the hearing. But that notwithstanding, is going to their mark will be affected because it's a very grave error.
As the court pleases.
As the court pleases, Your Lordship.
As the court pleases. My lord.
Yeah, go ahead, please.
Yes, my lord. Thirdly, the defendant's brief has no date. They didn't date their brief. This is also an error and quite surprising, my lord. And further, in their brief, instead of sheet number, they used charge number. My lord, this is not a criminal case. This is a civil case. You don't use charge number in civil cases, but rather use it you use charge number in criminal cases. And not civil cases. They ought to have used sheet. However, they use charge. My lord, these are the things that we want the court to also notify. And lastly, my lord, they filed a stay of proceedings. However, by virtue of Order 32 of the Federal High Court rules, I seek from this court to read out the provision, what it says, before I go further.
Go ahead, counsel.
Yes, as the court pleases. My lord, Order 32 of the Federal High Court rules, 2019, states that where any application is made to the court for a stay of execution or of the proceeding under any judgment or decision appealed from, the application shall be made by notice of motion supported by affidavit setting forth the grounds upon which a stay of execution of the proceeding is sought and a written address. My lord, we duly notified, we took note of the fact that the defendant submitted a stay of proceedings for this particular issue. However, they didn't file a written address to substantiate their stay of proceedings. They only filed grounds for the stay of proceedings, and this is not in compliance with Order 32 of the Federal High Court Rules 2019. My lord, we want this court to go on this, and we pray that this court should dish out the stay of proceedings that was filed by the defendant in regards to this issue.
Yeah, counsel to the defendant, please. What's your response on the objections? Abdul, are you there? The defense, do you have any response?
My lord, we do not have any. And we do not have any, Your Lordship.
All right. I'm going to uphold the objection of the plaintiff because in line with the rules of this court, you ought to have filed the motion accompanied by a written address as stated by the counsel. However, because of the need to proceed with this matter, we'll still proceed notwithstanding the defect on the stay of proceeding application. So the failure to comply with the rules will affect the marks to be allotted to the defendant. I so hold. So counsel to the plaintiff can... Yeah.
My lord, I shall now move into the substance. I shall now argue my issue 1 because I am taking issue 1, my lord, on behalf of the plaintiff.
Can we proceed now, counsel?
Yes, my lord. I
Objection, Your Lordship. Objection, Your Lordship.
Go ahead.
Thank you very much, Your Lordship. Looking at the statement of facts.
Yes, sir.
Thank you very much.
Counsel, what are you objecting to?
We are the owner of the issue 1 because the issue 1 is the issue 1 was couched by the defendant applicants because of the fact that that issue is trying to deal with a preliminary issue which was raised by the defendant. In that wise, since the application for the preliminary objection emanated from the defendant should be the first to argue. Then the argument of the argument of the respondent of the plaintiff respondent will now serve as a kind of defense to that preliminary objection. I hope I'm clear, Your Lordship.
Counsel, what that you are supposed to move your application?
Yes, Your Lordship.
That you have to move your application first.
Yes, Your Lordship. Before we do our own, Your Lordship, before we move our application, since they are the plaintiff, they are required as a matter of law to first move the substantive suits. Thereafter, we move our own preliminary objection. Then our own preliminary objection will now first be heard as a matter of law, since it is an interlocutory application. Thank you very much.
Yes, my lord. We have no problem with the defendant applicants going on with their preliminary objection, which is issue 1. We have no problem with that. Go on.
Your Lordship, I believe counsels to the plaintiff are pretending not to be aware of the practice in the court. Our preliminary objection is going against the substantive suits. So if the substantive suit has not been adopted, it has not been moved, it is deemed as if there is nothing before the court. So they have to move their own, they have to adopt their process, their originating process. Thereafter, we now go on with our own preliminary objection. Thank you.
My lord, may counsel for the plaintiff speak?
It is a substantive the matter for the hearing. So it is not an application that needs to be moved. Like I said, it's not an application. The plaintiff they have before an application. The matter today is for hearing. And so it is the defense that has and to is after the application that we know whether the subject the main case. The plaintiff has not moved any application because what they brought before is not application. So the defense, after the application, if the application sucks, then I hope I'm clear on that. All right. Counsel to the defendant, can you move your application now? Then in response to the application, the plaintiff will address issue 1. Because I believe your application for stay borders on that issue 1. So move your application and then the plaintiff will respond by addressing issue 1.
As the court pleases.
Okay. I said you can move your application. Yes, I can hear you.
Yes, my lord. We are considering, my lord, it seems...
Yes, I can hear you.
Yes, it seems network is not favorable at your end. That's why counsels are actually finding it hard to hear you. What you suggest, if it's possible for we to postpone this proceeding to a later time, maybe a time that will be convenient for you to be at a better place where there will be network and this proceeding can go on more smoothly, my lord.
Thank you, counsel.
Okay, so when do you suggest? Change the phone.
Your Lordship, would this honorable court will be okay with next week?
My lord, next week will be too far. The second session is on Saturday next week. Let this proceeding be shifted to tomorrow, which is Monday.
So we have to consider the expediency of the judge.
Yes, I believe the judge should be in a very good position to tell us when it's convenient for him to be in a better place where network will be fine.
Yeah, my lord, I'm very sorry I had a network breakage over here. I would like to suggest that whatever time and day that will be comfortable to the court, we'll force ourselves to also be comfortable with that stand.
Okay. I don't know if you can hear me, but if you can, let's make it on by 4 o'clock tomorrow. 4 o'clock.
Can you repeat the time, sir?
Tomorrow. 4 o'clock will be okay. I'll be in the office at that time. I believe the network will be better at that time.
As the court pleases, Your Lordship, we are very happy for that. Thank you.
Though the defendant, it is a shame that the defendants were pointing to the statement of fact as showing that they were agents. The counsel for the defendant, particularly on paragraph 11 of his brief, he pointed to paragraph 4, lines 2 of the statement of fact as revealing their capacity as agents for the federal government. Your Lordship, this only raised the question as to, are the parties bound by the statement of fact or the contractual document which they both voluntarily signed? The question can only be answered that they are bound by the contractual document and not by the statement of fact. And as such, since he cannot point to a particular line or paragraph in the contractual document which shows that they were acting as agents, they cannot prove to this court that they are not principals to this action, and as such cannot be sued. Your Lordships, the fact of Asafa Food Factory Limited is similar to the fact before this court, and I seek the leave of the court to give a brief statement of the fact.
Yeah, you may proceed.
Your Lordship, this case of Asafa Food Factory Limited involves the plaintiff. The plaintiff made a contract with the second defendant for the transportation of needle milk from South Africa to Nigeria. On arrival of these goods in Nigeria, the plaintiff also made another contract with the first defendants, who are shifting and forwarding agents, for the transportation of the aforesaid goods from Port Harcourt to Kano State. On arrival of these goods in Kano State, it was discovered that some amount of the goods were missing, and the plaintiff instituted an action against both the first defendant and the second defendant. In the Court of Appeal, it was the contention of the first defendant that they were agents of the second defendant, and as such cannot be sued or be made liable under the contract. But the Court of Appeal, in rejecting such contention, held that there was the transaction involves two distinct contracts, the first between the plaintiff and the first defendant, and the second between the plaintiff and the second defendant. Since the first defendant did not reveal that they were acting as agents of the second defendant under the contract, and since they use their own way bills, which goes to show that they are acting as principals, they cannot raise the defense that they were acting as agents. Your Lordship, it is a tried principles of law that any person that is not a party to a given contract will never be made liable or be made to gain any benefit from the given contract. And this is the law of privity of contract. And as such, any other party which the defendants are asserting that they are the proper parties before this court cannot be a proper party because the contractual document did not mention them. Your Lordship, I quite take notice of the defendant making in several paragraphs of their brief on issue 2 that the contract was ratified. Your Lordship, this is an error. Contract cannot be ratified. Ratification is possible in other areas of law, but not in contract, because considering the personal nature of contract, it cannot be ratified. And this is the position of law in Terri and Atkinson, where the court refused a son the right to enforce a contract made by his father in his behalf, even though the son was suing as the executor of the father. More so, in the case of Dunlop and Selfridge, the court also refused a manufacturer the right to enforce a contract made by a wholesaler with a retailer for his benefit. All this goes to show that contract cannot be ratified by third parties. Ratification is possible in other areas of law, but not in contract, Your Lordships. Your Lordships, since the defendants did not reveal from the contractual document that they were agents, they are liable as principals in this transaction. This is the position of the law in the case of Osigwe and PSPLL. Citation duly provided in my written brief of argument. Your Lordships, they do not reveal their capacity as agents, and as such, they are liable as principals. Finally, Your Lordships, assuming but not considering that the defendants were able to prove that they were agents, they will still be the proper parties before this court, because as it was stated in the case of Akinsanya and Longman, the court held that, for instance, a plaintiff whose car was damaged by the negligent driving of defendant's car driven by his driver, Mr. O, will be unable to claim from the defendant, the owner of the car, unless his driver, Mr. D, who actually drove the car, was joined as a co-defendant. That is because the liability of the owner is purely vicarious. There is no way the owner of the vehicle can be vicariously liable unless his driver, who actually caused the accident, is also sued and made liable. In determining liability in case of vicarious liability, both the agent and the principals are proper parties before the court, because the court used the agent as the litmus paper in determining the liability of the principal. The principal cannot be liable if the agent is not liable. Your Lordship, both parties are proper, and as such, even if they were agents, we were able to prove before this, they will still be the proper parties to this court. And as such, it is my learned and noble submission before this court that the defendants were unable to prove that they were agents, and as such, the court should dismiss their defense and hold them liable in this particular contract. Your Lordships, with this honorable submission, I shall rest my case, and as such, I so adopt my brief of argument, which has been properly filed before this court.
All right, Counsel. May we proceed to the third issue?
Respectfully, my Lord, I am Adesola Adetoun, counsel for the plaintiff, and I'll be conversing on issue 3, which states thus: I seek the leave of the court to read. Whether the High Court or not the Federal High Court has jurisdiction to entertain this suit. Your Lordships, as has been established in the case of Adere and Okwayo, recitations duly supplied in memorial given, that claims of the plaintiff determines the court's jurisdiction. And as has also been established in the case of Adetai and Ademola, citations duly supplied in memorial given, that is started establishing a court determines the court's jurisdiction. Counsel hereby humbly submits that the Federal High Court has the jurisdiction to sit here and entertain this suit. Your Lordship, it is very, very pertinent to know what jurisdiction is, as it is a basic term in this issue. In the case of Ogumoko and Mainland of Osun State, jurisdiction was defined as the basis, foundation, as well as life wire of access to court in adjudication under Nigeria civil process. Jurisdiction can also be regarded to as a special court, blood, as well as life of litigation, as upon it lies other proceedings. Your Lordship, since it has been established by Nigeria's judicial system that the rule of a court does not determine the court's jurisdiction, rather it's the statute that establishes a court that determines the court's jurisdiction. And the Federal High Court was established by virtue of Section 249 of the Constitution of Nigeria. And Section 251 of the Constitution of Nigeria also vested the Federal High Court with its jurisdiction. Your Lordship, the Federal High Court, by virtue of Section 251, subsection 1, paragraph D, I seek the leave of the court to read. Notwithstanding anything contained in this Constitution, and in addition to such further jurisdiction as may be conferred upon it by an act of the National Assembly, the Federal High Court shall have an exercise jurisdiction to the exclusion of any other court in civil causes and matters connected with or pertaining to banking, banks, other financial institutions, including any action between one bank and another bank. Any action by or against the Central Bank of Nigeria arising from banking, foreign exchange, coinage, legal tenders, bills of exchange, letters of credit, promissory notes, and other fiscal measures, provided that this paragraph shall not apply to any disputes between an individual customer and his bank in respect of transactions between the individual customer and the bank. Your Lordship, Toby JSC, in the case of NEPA and Edinburgh, citations duly supplied in memorial given, while interpreting Section 230 subsection 1 of the 1979 Constitution, now Section 251 of the 1999 Constitution, stated that parties in litigation is one of the issues or matters that arises while interpreting this section. Also, in the case of Adeyemi and Okwayo, citations duly supplied in memorial given, it was also held that the claims of a plaintiff determines the court's jurisdiction. Your Lordship, in order for this court to succinctly ascertain whether it has jurisdiction to entertain this suit, these two matters must be considered in relation to the statement of fact. Your Lordship, you will agree with me that the parties in litigations are banks, and also as regards to the claims of the plaintiff. Your Lordship, the claims of the plaintiff in this case is that there was a breach of contract by the defendant who is a bank. Your Lordship, since the Federal High Court has been given the jurisdiction to hear any matter between any matter or action between one bank and another bank. Your Lordship, this case should not be an exception. Also, Toby JSC in the case of Trade Bank PLC and Benin Enterprises, he also confirmed and reaffirmed that the Federal High Court has the jurisdiction to entertain banking matters. Also, in the case of NDIC and Okem Enterprises Limited, it was also confirmed that the Federal High Court has the jurisdiction to entertain banking matters. Your Lordship, flowing from the above, it is very, very evident through the statutory provision and the judicial precedent that the Federal High Court has jurisdiction to entertain any suit pertaining to any action between one bank and another bank. Your Lordship, lastly, the defendants may try to sway or divert the attention of this honorable court by asserting that the contract that exists between the both parties is a simple contract, hence the Federal High Court does not have jurisdiction to entertain the suit. But Your Lordship, counsel vehemently assert that the contract that exists between these both parties is a formal contract and not a simple contract. Your Lordship, according to Saget's Law of Contract textbook, it defines a formal contract as a contract that is under a seal or a deed, which must be in writing or typed on a paper or parchment. A deed is considered to be completed or executed when a deed is regarded to be completed or executed and its full legal effect when it is signed and sealed. However, Your Lordship, by the English Law Property Act of 1925, Section 73, and also by various laws in Nigeria, now it is either for someone executing a deed, is either you sign it or you make your mark on it. Your Lordship, it is very, very pertinent to know that there are some statutory requirements for some contracts. There are some contracts that they have to be under seal or deed before they become valid. Example of such contracts are contracts entered by companies, also conveyance of land, also conveyance of legal estate in land. Your Lordship, the basic and distinguishing difference between the simple and the formal contract, which the defendants or the opposing counsel failed to identify or is ignorant of, is that for a formal contract, it is always only a seal or a deed or a signature. What the simple contract does not need, it doesn't have any of the parties' seal. Your Lordship, so since the federal, there's no where it's written in Nigeria's statutory provision, either by judicial precedent or our constitution, that the Federal Court is bound to hear any formal contract. It is my humble submission that the Federal Court has jurisdiction to sit here and entertain the suit. And I pray this court to sit and air all the matters level for determination.
All right, counsel.
Hello.
I want to believe you are done with your...
Yes, my lord. The plaintiff, we are done with all our issues in response to the applicant's objection, my lord.
Okay.
As the court is.
So now will be time for rebuttal. We'll give 3 minutes.
My lord, before rebuttal.
Yes.
My lord, before rebuttal, I raised an objection and you promised me that you allow me to make my objection after they are done with their issues.
My lord, go ahead. I thought you want to incorporate it.
My lord, the defendant should restrict his objection to the rebuttal time. My lord, we're not here to play or do tight play. We should go according to the rules, my lord.
My noble lord,
nobody objected. Why should you object in house?
My noble lord.
No, please, let's allow him. Speak. I'm listening.
Yeah, thank you very much, Your Lordship. I was unable to hear when they started their argument, and unfortunately, I later logged in and I got to know that they have already started their argument. However, with what my co-counsel informed me now, number one is that ordinarily when before they started the argument, the requirement of law is that they should first adopt the reply to our preliminary objection, which was what I wanted to raise, but Your Lordship could not allow me to raise because they've already started the argument. That's number one. Number two, when we check the reply, number one, it does not show in any way that the process is a reply to our preliminary objection, my lord. It does not show that it is a reply to our preliminary objection. So we never thought of the process to be a reply or to our preliminary objection. Not only that, they did not sign it, which by the requirement of the law, in the case is not limited to the case of GTB against Toye. The citation is in our brief of argument. We have a citation for it in our brief of argument. It also provides that where a court process must be signed, and after it has been signed, it will also indicate who signed it. so as to differentiate it between a process that is a process that was prepared by a ghost. In this wise, we perused diligently and carefully the process filed by the defendant. We are unable to see where they signed it. My lord, our process is well signed, and it is also indicated there that this is the counsel that signed it, which means we hereby seek your lordship, we seek from your lordship to deduct from the mark. Number one, because of the confusion they caused to us, we could not know that the process they served us is a reply to our plenary objection. That's number one. Number two is the fact that they failed to cite. It is very, even as a matter of law, such process should be discountenanced with. It should be struck out. It should be thrown to the judicial dustbin of the court. However, we are trying to be very magnanimous and merciful to them. We are hereby seeking for the deduction of the mark only. Thank you very much. Before we go to our rebuttal.
My lord.
Yes, do you want to respond?
Yes, my lord. First of all, the defendant counsel raised an issue of adoption. My lord, you listen to me very well. We have adopted our written address before I entered into my appearance and providing argument for issue 1. My lord, you listen to me very well on that. Secondly, the defendant is talking of signatures. Can the defendant show me where in the process where it tried that he signed is? My lord, I currently have the Word document open. There's no signature on it.
My noble lord, the one I signed, my lord, the one I filed 30 minutes to the commencement of this proceeding. You have argued that, and my lord has penalized us for that. My lord has penalized us by deducting from our mark. So it has been deemed as a court process because we have been penalized for that. So since we have been penalized for that, it is deemed as a court process, and we signed it. We are now saying that your reply to our own preliminary objection, number one, it does not indicate that it is a reply to the preliminary objection, which is very grievous. It shows a diligent counsel should make sure that that he shows the title of the court process. Apart from that, you did not sign your own. We signed and also indicated the counsel that signed it. That's what we are saying, your lordship.
My lord.
Let's listen. I have heard the objection of the defense. One, with respect to the non-adoption of the process of the plaintiff as a reply to the preliminary objection or preliminary objections by the defense. On that, I think the reason why the defense is confused as to whether you adopted it or not, maybe as a result of the network failure. Because my humble self, I heard the plaintiff very clearly that before he proceeded, he adopted his processes as a reply to the defense preliminary objections. So on that, I find no merit on that objection, and so the objection is overruled. Then on the issue of signing, on the issue of signing the court process. Now, I want us to understand that this proceeding is guided by the rules of this court. And I want us to have in the back of our minds that we are not before a live court. And that is to say, we are not following the modalities stricto sensu of a live court, because this is a moot court. And so there are a lot of things that will be waived. There are a lot of things that cannot be complied with. In fact, if we are to comply with everything, we cannot proceed with this matter. In fact, the matter was not even begun by originating process. What was filed was just an argument on issues. Even the defense did not file statement of defense. And so these are not the conventional ways of commencing an action and defending an action. And so there will be no need for us to go into those intricacies or technicalities. That will really defeat the essence of this proceeding. So it's my humble ruling that the two objections are overruled.
As the court places.
As the court places.
Please, can we proceed now to rebuttal? The defense will give us rebuttal 3 minutes and then followed by the plaintiff.
My lord, I believe it is a reply on point of law. We should only be the one to talk. They don't have anything to say again as a matter of law. It's a reply on point of law.
May you proceed?
Okay, thank you very much, Your Lordship.
My Lord, if the defendant should raise an issue that is new, I believe we have the right to reply to such.
Of course. Don't worry about that.
As the court pleases.
My Lord,
yes.
A learned colleague from the other side of the bar who argued issue 2, made a submission as to whether or not a contract can be ratified, that a contract cannot be ratified. My Lord, I found it very uncommendable because when we are talking of agency, we are still talking of a kind of contract. That is why it is called contract of agency. We have various textbooks like Okani, wherein it is provided that the kinds of among the kinds of contract that we have, there is contract of agency. And when we are also talking of the types of agency, Your Lordship, we have agency by ratification. Agency by ratification, Your Lordship. We rely on the case of sentence against Haoli, my Lord, who paste the facts and the summary of the facts and also the decision of the court into the court's room text for the purpose of affirmation, that we have agency by ratification, and which means that which goes against the submission of the counsel to the plaintiff, that there is nothing like contract by ratification. So we are saying there is contract by ratification in a situation whereby an agent entered into the contract and the principal later ratified it either expressly or impliedly. So on that, it is our submission that there is a contract by ratification as against what was submitted by the counsel to the plaintiff. So for the other report, I would like to defer proceeding to Atere for the purpose of the other reporter. Thank you.
Yes, you may proceed.
Okay, thank you very much, Your Lordship.
Thank you, Your Lordship. Your Lordship,
yes,
it is just not interesting seeing my learned brother misapplying case laws. My Lord, we are not happy with that, Your Lordship. The learned brother cited NEPA versus Edegberu, citation duly supplied, with the holding that in determining the jurisdiction of the Federal High Court, parties in litigation is one of the issues that arise. Your Lordship, then what are the other issues? Your Lordship, the correct holding of the court is that two matters arise, and they are parties to the suit and the subject matter. Your Lordship, the learned brother also cited the 2003 case of Trade Banks PLC versus Benin. Your Lordship, citations duly supplied, with the holding that the court reaffirmed the established jurisdiction of the Federal High Court to hear cases between a bank and another. Your Lordship, whereas the learned brother has contradicted himself by citing the case of Adeyemi versus Opeyori, with the holding that the claims of the plaintiff determines the court's jurisdiction. Then what is the subject matter in this present case, Your Lordship? It's a simple contract of tenancy agreement, Your Lordship. A simple contract of tenancy agreement. So in the 2003 case that she has cited and misapplied, Your Lordship, the issue is before the court is whether a claim against a bank by a third party, not its customer, for wrongful payment of its crossed check, falls within the exclusive jurisdiction of the Federal High Court. With Your Lordship permission, I quote the words of your brother. Your Lordship, it goes like this. I have no doubt that the respondent in the case at hand can sue the appellant in conversion for the proceeds of the check, with the appellant pay to a stranger who is not the payee of the check. The plaintiff respondent's case is simply a thought of conversion, and the action filed by the plaintiff respondent against the appellant can be entertained by a state high court. Your Lordship, the court continues by making reference to the territorial case of NDIC versus FMBN, Your Lordship, that I have even cited in my brief that for the exclusive jurisdiction of the Federal High Court to be sustained under the aforesaid section, the civil cause or matters must arise from banking, banks, and other financial institutions. Your Lordship, in my humble view, it can hardly be said that the respondent's cause of action falls within the exclusive jurisdiction of the Federal High Court. Thank you, Your Lordship. I will not agree to the fact that the counsel has lied to this court, but the issue with the learned brother is just that he is not well informed, and it is the duty of the court to give the proper interpretation of law, and we counsels are to guide the court. Your Lordship, it is a matter of law that a counsel will not be heard on any argument not covered by his brief. Your Lordship, I wonder why my learned brother was arguing anything with respect to formal contract or so. It's a simple, it is trade law that a person can enter into a person can enter into any contract with another person. My lord, this contract deals with, Your Lordship, tenancy. Your Lordship, tenancy.
My lord, objection. Counsel time is over, my lord.
It's supposed to be 3 minutes.
Yes, my lord.
It's supposed to be 3 minutes. Yes.
Yes, he went ahead of his time by a very significant amount.
I did not.
All right. I think you can hold it there since you have exhausted your time. I've gotten your point. So I don't know if the plaintiff wants to say something. Remember, it's 3 minutes.
My lord, we have something just to say in regards to the first rebuttal that was given by the lead counsel for the defendant. My lord, he cited a case before this honorable court. First of all, that case is not a Nigerian case. Hence, it's persuasive. Lord, and secondly, he didn't provide a citation for that case. My lord, it was stated in the case of in a case I'm going to post on the courtroom test right now, that if a counsel comes to court and it does not provide citation for that particular case, the court of law should not rely on such case, but rather we throw away such case. My lord, and we are stating that this honorable court should discontinue such case, and hence that first rebuttal should be thrown away.
My lord,
all right.
That is
all right.
Another
that would be no, don't worry. There should be an end to argument.
Thank you, my lord.
Now you have done your rebuttal, and the plaintiff has already responded. Okay. I want to note the following things, and then I will proceed to dish out the judgment. The judgment that I'm going to dish out.
Pardon me, Your Lordship.
Yes.
The plaintiff seems to have a rebuttal.
My lord, yes, our time is extended.
My noble lord, there cannot be
My
reply
lord,
on
please,
reply on point of law.
time is counting, my lord.
The only thing they have to do, the only thing they are required as a matter of law to do, is to first note where they want to rebut, so as to know whether or not they are trying to go, whether or not the defendant, while giving the reply on point of law, raise a new issue. They don't have. They cannot say if they want to give rebuttal, we also want to give rebuttal.
Cancel. I've gotten your point. Cancel to the defense. I've got your point. The plaintiff, when you stop, we already thought that you were through with your rebuttal, and as such, we thought you have waived your right to continue, even though you had more time remaining. So we cannot be waiting for counsel. So we cannot go on and on arguing the same matter and on and on. I have read your briefs, your different briefs. I'm sure whatever you are going to say it will not be different from what you have in your brief. It's just to emphasize. And so there may not be need for that.
My lord,
so that we'll be able to have a successful
network is an issue.
Please, I want to be sure that
that's why I couldn't say whatever I wanted to say earlier. Please, just grant him. If it's a minute, let him speak, my lord. We plead. This is a temple of justice, my lord. This court should not rely on technicalities.
My lord will not be happy with that. My lord will not be happy. My lord will not be happy. We want to rebut also, your lordship.
My lord has good on it, please. Counsel, may you see.
My lord, we will not be happy with this. We also want to rebut. It's going to be partiality to us.
Defense, the issue of partiality does not arise. In fact, the rebuttal will not affect anything. Let's just hear this. But remember, you cannot speak more than 1 minute. You know, I allowed you defense to speak, even you spoke more than 3 minutes. But I know why I had to allow you to land. so that you can be able to air your view. So please, the plaintiff, let's allow them just for 1 minute. Let's believe that it's because of network that they were not able to. So please, can you quickly do that? 1 minute, please.
Your Lordship, I was disconnected because of network issues. Okay.
Yes, go ahead.
All things being equal, Your Lordship, my rebuttal is on point of law. And this point of law, I would like the court to take notice of Section 174 of the 1999 Constitution, which made provision for the powers of the Attorney General. Your Lordships, it surprises me that I want to draw the attention of the court to Your Lordship, to the paragraph third to the last of the defendant's brief on issue 2, particularly lines 2. I quote what they stated there. The defendant asserts that the Attorney General of the Federation applied to be joined as a proper and necessary party, without which the suit cannot be properly determined. Your Lordship, it seems the defendants are making this assertion. They are in ignorance of the provisions of the Constitution as to the power of the Attorney General. The powers of the Attorney General is limited to criminal cases. Unless they can prove to this court that the matter before this court is criminal in nature, so as to join the Attorney General as a proper party, their assertion is in error on the point of law. And as such, Your Lordship, I pray this honorable court to discredit, discard, and throw away the submission of the defendant on issue 2 as to the joining of the Attorney General to this suit, because as was stated in the case of UAC and my boy, that you can't place something on nothing and expect it to stand. And as such, the entire argument on issue 2 should be thrown away, because the submission, the court cannot grant the submission because it is against the 1999 Constitution. The Attorney General's power is limited to criminal matters and not civil matters, and as such cannot be joined as a party to this suit.
My noble lord, I have to say something, Your Lordship. It is very important, Your Lordship.
My lord,
it is extremely very important, Your Lordship. What we have, they are asked to give rebuttal. They are asked to give rebuttal. They were saying something what they should have said in their reply to our preliminary objection. We filed our preliminary objection. They have replied to it. They kept quiet. Then we sent our own. We're replying on point of law. They are now standing up in order. They now went further to go and argue against what they should have argued in their reply brief. My lord, for the purpose of legal education, they should be sensitized. They should be educated. They should be oriented. They should be taught how court proceeding is being done. Under normal circumstances, they should have said that in their reply to our preliminary objection. It is very frivolous.
Your Lordship, I object to this.
My lord,
no,
I object to this reply.
My lord, thank you, my lord.
Unless the defendant can prove that,
as the court please.
Let's have order. Let's have order, please. Please, let's have order. Now, one of the things that I want us to understand is that as a counsel, you have a duty to respect your colleague. In fact, it is one of the rules of professional conduct. You are not supposed to speak about your colleague in an insulting way. And also, if you want to disagree with your colleague, there is a better way to disagree. You may say that, well, my learned friend here is in error, or that his position is not the current position of the law, or that it appears, but let's avoid attacking our colleague. That is against the rules. Clients will come and go, but we are together in this profession, and you are not supposed to, after a trial, and then you try to make enemy with your colleague. I'm just saying this obiter anyway, but I want us to understand that as colleagues, we should respect each other, and we should assert our own position without insulting each other. Now, you two have performed
My lord,
wonderfully well. Your
my lord,
arguments, yes.
please, the defendant lead counsel, may he pause to mute his mic?
Okay, is it affecting?
I'm hearing a lot of echoes.
Yes, that's true. All right, please mute your distance, please. I think he has done that. All right. May I proceed now?
Yes, my lord.
Can I proceed?
My lord.
Okay. Now, first, I want to commend all of you, the defense and the plaintiff. People have performed wonderfully well. The arguments and both the briefs, I've been able to go through all the briefs. I've also listened keenly to you people. I think I'm encouraged that this profession has a very great future. Now, I want to talk about the issue of how to address your fellow colleague in court. Please, it is my learned friend. I heard some people calling my learned brother. My learned brother is meant for the bench. So if you are a judge, you want to refer to a fellow judge, you say your learned brother and not your learned friend. But as a colleague in court, as a lawyer, you refer to your fellow lawyer as a learned friend. Now, thirdly, some people were, when they were making the argument, they were saying, my client. Once you are before the court, it's no longer my client. You should be able to refer them as either the defendant or the plaintiff. Don't make the mistake of calling them your client when you are in court. I hope I'm being heard.
Yes, my lord.
Okay, then, lastly, the issue of AG. The Attorney General, the argument that Attorney General does not have the jurisdiction to defend civil matter is untenable, it's unknown to our law. The proper position is that the Attorney General is the chief law officer of the state or of the federation. And so, apart from the prosecutorial powers conferred on the Attorney General by virtue of the said provisions of the Constitution, Section 174, of the Constitution and Section 211 when it comes to that of the state. The Attorney General also, as the chief law officer, represents the state or the federation on civil matters. So when you see the federal government, it's the Attorney General that will come, whether it is civil or it's criminal. It's the Attorney General that represents the federation, and it's the Attorney General of the state, is the one that represents the state. I hope that is clear.
Yes,
Then
my lord.
I will proceed to address some points. First, I want to begin with the plaintiff. Why I want to say this now, so that we can all learn before I give the judgment. Because I know if I give the judgment now, everybody will run away. You're not listening to this one again. So I'll be very quick. Now, somebody submitted. Okay, let me just read out the judgment. I believe some of those things will be addressed there, so that I will not be repeating the same thing when I'm reading the judgment. So just permit me to read the judgment. Let me be sure that you are hearing me. I'm sure you can hear me clearly.
Yes, my lord.
The defense,
Yes, your lordship.
Okay, I have carefully and painstakingly perused through the arguments posited by both parties. It is fact law. Sorry. I want you to know the one I'm talking about is the first issue with respect to issue number 1. Issue number 1, which is as to whether the arbitration clause needs to be effected before the matter can be taken to court. It is right law that where a clause in an agreement provides that any difference or dispute in an agreement shall be referred to an arbitrator, both parties ought to honor and comply with the provisions of the clause. See the case of SCOA Nigeria Limited versus Sterling Bank PLC, 2016 Law Pavilion Law Report, and the citation is applied. It has been heard in Jambalaya and plethora of cases that parties are bound by the terms of an agreement which he or she voluntarily enters. In the instant case, arbitration clause is one of those terms which the plaintiff, Benz Bank PLC, and the defendant, Benz Bank PLC, agreed upon. It must be emphasized that arbitral proceedings are recognized means of resolving disputes. Are we together?
Go. Yes, my lord.
Yes, my lord.
Okay. Is a arbitration proceeding is a conventional process, and parties cannot be forced to arbitrate a dispute unless he agrees to it, and the court are duty bound to enforce it. See the case of Sino Agricultural Limited, Company Limited by Minister of Finance, 2013. Citation supplied. Also, see the case of DICO, Metro Line Nigeria Limited versus DICO, 2018. It must be noted that the inclusion of an agreement to submit a dispute to arbitration does not generate the hit of hostile jurisdiction of the court, as argued by the plaintiff counsel. It must be noted that the inclusion of agreement to submit a dispute to arbitration does not generate the hit of hostile of jurisdiction of the court, as argued by the plaintiff. It merely postpones the right of either of the contracting parties to resort to litigation. Where in a contract there is a clause on arbitration, it is considered as a sine qua non, that is, a condition precedent to the exercise of jurisdiction. I've started a case there, and the citations are also supplied. It must be further noted that submitting to arbitration is a condition precedent to the exercise of jurisdiction. Thus, the only remedy available to an aggrieved party is to apply for a stay of proceeding against intended suit. This can only be validly done before taking any step towards the proceeding. It is my view that any step outside from entering of appearance will rob the court of the power to grant the stay of proceeding, and will also foreclose the right of the aggrieved party to the enforcement of the arbitration clause. I've cited another case there. It is important to state that the law is clear on how arbitrator can be appointed. The parties are at liberty to agree on how the arbitrator will be appointed and who is authorized to so appoint. This is in line with laissez-faire liberalism, freedom of contract. Let me at the expense of verbosity, but born out of necessity, plug out the provisions as ingrained in the statute book, if systema verba, section 7 sub 2 sub A, paragraph A of the arbitration act provides. For the sake of time, I will not read what it provides. You will see the judgment. It is my view that a cursory look at the above provision clearly shows that the parties are at liberty to decide who and how an arbitrator should be appointed. It is only when the contract fails to provide for the mode of appointment that the law will intervene. Therefore, I disagree with the counsel to the plaintiff on this point. Thus, there is no infringement or an affront on the principle of nemo judes in causa sua. Where there is likelihood of bias in an arbitral award, it can be set aside upon application to court. Therefore, it is my view that this court lacks the jurisdiction to hear this case due to the fact that arbitration clause has not been complied with. Consequently, considering the fact that the defendants have not taken steps towards defending this suit and considering the application for stay before this court, the defendant cannot be said to have waived their right to arbitration. I therefore hold that this court shall decline from hearing this matter until the provisions of the arbitration clause is complied with. I so hold. I hope I'm clear. I'm going to make the judgment available, and we will all see the citations there. They are all recent cases.
Thank you very much.
Now, with respect to issue 2, whether Zenze PLC is acting in capacity of an agent for the federal government and hence cannot be sued, I have carefully perused through the arguments of both parties on the instant case. It is right that qui facit per allum facit per se, he who acts by another acts by himself. Thus, the general and notorious position of the law is that an agent does not act for himself, but for his principal. Thus, I agree with the defendant on this point.
As your lordship pleases.
However, to avoid slavish adherence to this principle, our courts have over time stated the distinct legal implications when an agent acting for a disclosed principal and when he is acting for an undisclosed principal. Before I proceed further to state my view on the above issue, I proceed further to state my view on the above issue, it is important to clearly state the position of the law as it applies to disclosed and undisclosed principle. First, pertaining to disclosed principle, that is where it is clear from the circumstances that the agent was acting ab initio on behalf of a disclosed principal. The established position of the law is that an agent of a disclosed principal acting within the scope of his authority is ordinarily not personally liable on a contract he entered on behalf of his principal. It is my view that an agent acting on behalf of a disclosed principal incurs no liability and cannot be sued. See the case of Okafor vs. Ezenwa. Also cited about 3 cases there, all recent cases. In other words, the proper person to sue or be sued upon the contract entered into by such an agent within the scope of his authority is the principal. See the case of Osigwe versus PSPL Management Consortium Limited. Okay, I want to scroll down. On the other hand, where an agent acts on behalf of an undisclosed principal, the aggrieved party can sue the agent. In other words, the agent will be held liable as the principal. However, if the principal is undisclosed at the time of the transaction, but subsequently discovered, the aggrieved party may elect to hold such principal liable because he is the real party in interest. Therefore, it is my view that the defendant is an agent. However, the defendant acted on behalf of an undisclosed principal. The law is settled that a plaintiff can elect to sue the agent or the principal, not disclosed at the time of the suit. Thus, failure of the plaintiff Bank PLC to sue the principal, federal government, that to sue the federal government is not fatal to this case. Therefore, I hold that the defendant is a proper party before the court and can be sued. However, it must be noted that if the principal wishes to be joined, this court will oblige him. This is because the concept of undisclosed principal is an exception to privity of contract. However, where the plaintiff elects to sue the undisclosed principal, there will be need to join the agent, and all liability will be, where the plaintiff elects to sue the undisclosed principal, there will be no need to join the agent, and all liability will be on the principal. In a nutshell, although I agree with the counsel to the defendant that the defendant is an agent, however, I hold that the defendant can be sued alone on the ground that he contracted on behalf of an undisclosed principal. The reason for this position is because by virtue of the contractual document which the plaintiff made reference to, the defendant contracted as if he was the principal. He signed on behalf of himself. There is nothing in the document to show that he was acting on behalf of any principal. So on that note, he incurs liability. That is an exception to the rule of agency. That is why we have disclosed and undisclosed agents. So the legal implication differs depending on whether an agent acted on behalf of a disclosed or undisclosed agent. That is to say, in a nutshell, although I agree with the counsel to the defendant that the defendant is an agent, however, I hold that the defendant can be sued alone on the ground that he contracted. Hello, counsel, are you with me?
Yes, my lord. Yes, my lord.
Please, did you hear my submission with respect to issue number 2?
Yes, your lordship.
No,
we are very pleased
no,
with
my
it.
lord. The plaintiff didn't get the last part of the
Okay, the number two
submission.
issue is the number 2 issue as to whether the plaintiff can be sued. I mean, the defendant can be sued, or whether the defendant is an agent and so he cannot be sued. The submission there. Let me read the last part again. I'm sure it seems I was cut off by the network. I said, in a nutshell, I agree with the counsel to the defendant that the defendant is actually an agent. However, I hold that the defendant can be sued alone on the ground that he contracted on behalf of an undisclosed principal. Why he is undisclosed is because in the contractual document, there was no mention of any principal. The agent contracted as if he was the principal. And where an agent contracts as if he was acting as the principal, the aggrieved party can sue the agent. So the agent can be held personally liable. But if peradventure at the time of the suit, the main principal surface, then the aggrieved party has the option to choose who to sue. He can decide to proceed against the agent, or decide to proceed against the principal. So where he proceeds against the agent cannot come and deny liability on the basis of being acting for on behalf of another principal. So if you want to act as an agent, it must be very clear in the document. When you are signing for somebody, there must be a sign that you are signing for on behalf of somebody. There is usually, when you are signing for somebody in a contractual document, there must be an F, something like an F sign at the back of your signature. Signing for. That's something, once you see that in a document, you will know that somebody signed for and on behalf of another person. And so there is nothing in the agreement that shows that the defendant was actually signing on behalf of the principal. So that is why I said I agreed with the defendant to the extent that he's an agent. That is okay, he's an agent. But in this matter, he acted on behalf of an undisclosed principal, and so he can be held liable. So the suit before the court is proper.
As the court pleases.
That is to say, he can be sued. Yeah, with respect to the third issue as to whether the High Court and not the Federal High Court has jurisdiction to entertain the matter, I'll quickly go to. It is settled law that jurisdiction is conferred by statutes. It has been held in plethora of cases that the jurisdiction of court is not only determined by parties before the court. Rather, the issues or subject matter before the court shall also, in deserving cases, be considered to ascertain the proper court that is imbued with jurisdiction to hear the matter. See the case of Rahama Brothers Limited versus MPA 2019 Law Pavilion Law Report. The citation is supplied for reference. However, as stated earlier, jurisdiction of the court is a creation of law. It is the Constitution that has specified the jurisdiction of the Federal High Court, and such provisions must be complied with. This is because the provisions of the Constitution are like the mountains of Gibraltar, which cannot be moved or altered. See the case of Soswan versus Oba, 2012 Law Pavilion Law Report supplied. Flowing from the above, the jurisdiction of the Federal High Court to hear the instant case is ingrained in the grand norm. Let me, at the expense of verbosity but born out of necessity, plug out the provisions that confer this court with jurisdiction to hear this matter, where it is ingrained in the Constitution, if Sissima Baba. Now, Section 251 sub 1D. Section 251 sub 1D. A careful look at it. I don't want to repeat it because of time, because sub 1D is a very long provision. But I'll quickly go to my submission on that. I hope I'm heard. Are we together? Counsel.
Yes, my lord. Yes, my lord.
From the above clear letters of the Constitution, we do not need a soothsayer. Neither is there need to travel all the way to Damascus to seek help before we can give life and understanding to the implication of the above the provisions. Therefore, it is my humble view that this court does not only have jurisdiction to entertain this matter, rather its jurisdiction in this case is exclusive. I therefore hold that this court has jurisdiction to the exclusion of any other court to hear this matter. Flowing from the argument of the counsel to the defendant, it is pertinent that I address the extraneous issue raised by the defendant's counsel. First, I agree with the defendant that if the action was against the federal government, the state high court would have jurisdiction, notwithstanding the provision of section 251 sub 1 P, Q, and R. This is because even if the defendant is an agency of federal government, that alone is not enough to confer jurisdiction on the federal high court in all cases. In addition to the above, the subject matter of the action must fall within the jurisdiction of the federal high court in order to enable the court to exercise its jurisdiction unfettered. I started a lot of cases there, all current cases. Thus, it is my view that if the plaintiff had proceeded against the undisclosed principal, that is the federal government, the proper court would have been the state high court, since the matter borders on simple contracts. However, the instant case borders on two banks. The relevant law is therefore section 251 sub 1D. The relevant law in this case is section 251 sub 1D and not section 251 sub P, Q, and R that talks about agency of federal government. Because it is not, the bank is not an agency of the federal government, and so the issue of agency of federal government does not arise. Thus, I disagree with the defendant's counsel when he argued that the issue between the two banks did not arise from banking, bills of exchange, etc. With due respect to the counsel, it is a wrong interpretation of the law. The requirement of matters arising from banking, bills of exchange, and other fiscal measures applies only to actions against the CBN, Central Bank of Nigeria. I therefore hold that this court has jurisdiction to hear this matter. Okay. That is the end of the judgment on the substantial issue. Now I want to...
As the court pleases.
I want to talk about this last point. I want you to take a look at that provision, section 251 sub 1B. Look at it very well. Now, when it comes to issues between banks, when you read it from the beginning, you will discover the wordings of the letters of the Constitution, the wordings of the Constitution. When it comes to the issue of arising from bill of exchange, blah, 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 is referring to central bank, and there are plethora of authorities on that. When it comes to issues of between two banks, there is no exception. The only exception is contained in the proviso. And what does that exception say? When it is a matter between a bank and individual customer. A bank and individual customer. Also, if there is a relationship of banker and customer relationship between two banks, it will go to state high court. You know that the relationship of banker and bank and customer, the relationship of customer, bank and customer can arise between two banks. Yes, a bank can be a customer of another bank. That is the only time that the state high court will have jurisdiction. But when it apart from issues of simple contracts that may arise between two banks, apart from I'm not talking about simple contract. I'm talking about apart from issue of banker and customer relationship that may arise between two banks, the High Court does not have jurisdiction to hear matter between two banks. It is only the Federal High Court that has the jurisdiction to hear matters between two banks. I know there will be a lot of issues agitating your minds that you want to point out, but I believe by the time you get the judgment handy, you'll be able to express concern. But let me still hear some of your reservations. Perhaps you can be able to look at them and throw more light on them. If there is any confusion, I hope I've not ended up confusing you. Yes.
But I believe the plaintiff would like to speak on the first issue which you addressed.
Yes.
Just a reservation. We very much still believe that this matter cannot go before the arbitral panel that will be set up by Zenze Bank. Because why? Zenze Bank is party to this dispute. And by that fact, if they should force Ben's Bank to come before an arbitral panel set by them, they'll be simply breaching the principles of natural justice, which is never to get started as well. No man shall be a judge in his own case. Now, this principle is very clear. Yes, this court can apply the blue pencil rule over the arbitration clause and nullify it. However, the other contractual terms is still valid, my lord. Okay.
Now, the issue of blue pencil rule, let me start with that particular principle. I'm very, very much aware of the principle of blue pencil rule. Now, the blue pencil rule is usually adopted to allow a contract to be enforceable. You know, a contract can contain some terms may be legal, whereas some terms are illegal. So the blue pencil rule is applied to isolate all those terms in a contract that are legal and enforce them so that the whole contract cannot be rendered unenforceable. Now, the case you cited was not talking about arbitration. The case you cited is where parties decide to host the jurisdiction of the court. You know, parties can contract that if any matter arises in this our contract, nobody should go to court without making provision for arbitration. That is the kind of term that was removed by the application of blue pencil rule. It was not an arbitration clause. An arbitration clause is provided by law. When it comes to the hierarchy of judicial precedence, you know that statutory authorities take precedence over judicial authorities. Arbitration is provided under the Arbitration and Conciliation Act. It is a law. And where parties willingly decide to incorporate an arbitration clause in the agreement, they are bound by it. Now, the issue of bias. Let me look at the issue of bias. It is not the defendant that will sit over the matter. Rather, the defendant was given the authority to appoint whoever that will sit as an arbitrator. Now, if you have problem with bias, at the end of the judgment, which is called award, at the end of the arbitral proceedings and the arbitrator gives award, if you have any challenge as to bias, the same law has provided a way to be able to enforce your grievances. How? You can overturn the decision of arbitrator by alleging that there was bias. And so it's only after the arbitration has been concluded and there is an award, you can proceed. There are provisions of the law as to when an arbitral award can be set aside. And one of them is where there is likelihood of bias. So when it comes to the appointment, parties can decide whatever they have. The freedom of contract principle overrules everything. You can decide whatever you want to decide. So I think it's a misapplication of the principle of audio trampatam and nemo judice in cassation. Nobody is denying any party of that. They willingly entered into that contract and they gave that. In fact, if you read the same, don't be. Can you hear me? Sorry, it appears I was thrown off by the network and I was here talking and talking.
No problem.
All right.
But what I'm trying to say is that there is no issue of bias at all. If there is any issue of bias after an arbitration proceeding, parties have opportunity of going to court to challenge the arbitral award based on bias. So when it comes to appointment, parties have the exclusive right to decide on how. And of course, the defendant or the plaintiff was not sleeping when they entered into the agreement. And so the sanctity of contracts must be maintained. If not, there will be chaos in commercial transactions if people are allowed to deviate from a contract where they willingly and voluntarily entered into. So I think that's the rationale. And like I said before, I don't know if you heard it, that when it comes to judicial precedence, statutory authority takes precedence over case law. And the blue pencil rule that you cited was not used to stop arbitration. It was only used to remove illegal terms in a contractual document, not arbitration. So it was not arbitration that the blue pencil rule was applied on. It was not an arbitration. It was illegal provisions in a contract in order to save the contract and not to allow the contract to be entirely unenforceable. They decided to apply the blue pencil rule in order to separate the unenforceable terms from the enforceable terms so that parties will not lose the essence of the contract. I think that's the import of the blue pencil rule. And it's not to stop the enforcement of.
Yeah, thank you very much, Your Lordship.
I don't know if
thank you very much, Your Lordship.
Let's look at
on our own part, we really appreciate the erudition and dexterity displayed in the judgment just given. We are very happy for that. However, Your Lordship, we have a reservation also, and our reservation is about what occurred during the proceeding. Number one, when we raised our own issue about failure to sign, failure to adopt, and things like that, Your Lordship, your Lordship voluntarily came up for by saying that this is mooting, this is not like real court, we cannot be so strict, or we cannot be so strictly adhering to real life courts ways of proceeding. However, Your Lordship, these are the technicalities raised by the counsel to the plaintiff to an extent that you deducted from our own mark. So if you should deduct from our own mark on the basis of such technicality, and when it comes to theirs, you fail to deduct from their own because of the technicalities they breached, we are very, we are very unhappy with that gesture, Your Lordship. Thank you. I hope my Lord heard everything I said.
All right. I even though I would have appreciated it if you had reminded the court on the objections of yesterday, but that notwithstanding, the truth is that there are some of the objections that go to the root of the matter. Some of the objections that go to the root of the matter, they are the ones that I actually addressed. That the ones that go to the root. So anyone that affect the substantive issue, I have to address them. I think that's just the basis of it. Not really that I decided not to It's discretionary, and I think the discretion was exercised judiciously and judicially.
Thank you very much, Your Lordship.
So it was not. So, any other observation, or at least on point of law? I want us to really, one of the essence of this meeting is for us to discuss together and to learn as well.
Thank you.
So, if there's any position that is not clear, just A of you right now. Perhaps, of course, we may not agree, but yes.
Thank you very much. I also have a kind of reservation regarding why you were giving judgment on the issue. One, you said, you talked about condition precedent by saying that failure to first go for the arbitration is a condition precedent, which you now went further to say something which I want you to clarify by saying that it will not, that will not give the court the go-ahead to strike out the case. Instead, there should be stay of proceeding. Am I right? Am I right in quoting you, sir?
Okay.
So the problem I now have there.
Okay. Yes, what's the problem?
So the problem I have there is that I believe condition precedent is one of the ingredients highlighted in medical law against dealing. That in a situation whereby there is a condition precedent, for an instance, there is a requirement as a matter of law that before a matter is instituted, there should be a pre-action notice. For an instance, in the case of Amadi against NMPC, where the plaintiff failed to first serve a pre-action notice on the defendant, I believe that was also a basis of the court denying itself of jurisdiction, that since the condition precedent of pre-action notice has not been fulfilled, the court cannot go further to hear the matters. So I want you to please enlighten me and educate me on that. Thank you.
Okay. When it comes to issue of jurisdiction, there are many legs, or let me say there are many lanes. There are many sub-issues under issue of jurisdiction. So it depends on the reason why the court will lack jurisdiction. The consequences are not the same. That is exactly what I want to say. The consequences are not the same. When it comes to arbitration clause, the consequences are well stated by the law. The only remedy that is available to an aggrieved party who wishes to enforce an arbitral or an arbitration clause is to ask for stay of proceeding. That is why I said initially clearly that arbitration clause does not host the jurisdiction of the court, rather it postpones it. But it is considered as a prerequisite to the exercise of jurisdiction because it needs to be complied with first as a condition precedent. So when it comes to pre-action notice, that one is a core issue of jurisdiction, and in such cases the matter will be struck out. But the same law provided that the only remedy that is available to an aggrieved party when it comes to arbitration clause is to ask for stay of proceeding. You cannot ask for any other thing. It's only stay of proceeding, and that's what the law provides. We cannot question the law. There are authorities that have cited, in fact, in recent cases. I'm sure none of the cases is less than 2015. None of those cases, most of them 2019, 2018 cases. So that's just the position of the law when it comes to that. So what I'm trying to say is that the consequences of issues of jurisdiction differs. The consequences differs. Some it can lead to dismissal, some it can lead to striking out the matter. Or in this case, it can lead to stay of proceeding. Go and deal with the matter first and then come back. But in whichever case, whether it is stay of proceedings or not, the matter is not going on. That's the most important thing. The matter cannot go on until the arbitration clause is complied with. But however, I want us to know that the two parties can agree to waive the arbitration clause. So both parties, but one cannot decide on its own to waive it. The two parties can decide, okay, no, let's not use arbitration again. Let's go to court, and the court will now assume jurisdiction. That's why I say you only postpone the right of the parties to go to court. It does not completely extinguish the right. I don't know.
So thank you very much for the legal education. Thank you.
I've been able, but at least one. If I may not have been able to clarify your point, but what I want you to know is that the consequences of matters differ. And as far as the law is concerned, the consequence of failure to adhere to an arbitration clause is that the remedy available to the other party is to ask for stay. That's just the position. There is no other thing that he can ask.
Your Lordship,
Yes,
this
go ahead.
council has an observation here with
Yes,
respect to
go ahead.
your judgment with respect to the first standpoint. We humbly
Issue one, yes.
understand. Yes, we humbly understand your on issue 3, Your Lordship. Issue
Yes.
3, first standpoint.
Yes.
Okay, like you
Yes.
were kind of okay. You were saying that that particular standpoint was not maybe perfectly relevant to the issue at hand, and you know we are the defendants and we are the one
Yes.
bringing the preliminary objections. So it is
Yes.
our motive to just get this case at hand struck out of the court. Now, we were expecting arguments from every possible angles, like maybe a brilliant counsel may want to argue that this particular bank is an agency of the federal government. That was the reason we came out with that. And secondly, Your Lordship, pertaining to your judgment with respect to, okay, that means you have ruled that notwithstanding the subject matter, once a bank is suing another, it is going exclusively to the High Court, to the Federal High Court. Did I get you wrong? Did I get you right?
Okay, let me clarify that. In fact, in my wordings, I said in deserving cases.
Okay.
In deserving cases. Why I said that deserving cases? Because there is one exception. Why?
Okay.
That one exception is where there is banker and customer relationship between the two banks.
Okay. And Your Lordship, wait. Yeah. That particular proviso to section 251 sub 1D.
Yes.
Is it the intention of the proviso to confer an exclusive jurisdiction on the state high court with respect to matters of a bank and individual customer, or a concurrent jurisdiction with the federal high court and the state high court to entertain the matter? Good.
That's a good question. I don't know what I said about it, but let me reiterate the position. When it comes to that, both the federal and the state high court, they have concurrent jurisdiction.
Okay.
Yes, you can decide to proceed to the. It's not exclusive to the federal high court.
Thank you, Your Lordship.
When it comes to that, so then when I talk about, when you read it very carefully, I know there is this, there is temptation to think that the part of the provision that says arising from banking, foreign exchange, coinage, legal tender, bill of exchange. I have the provision here with me. Those ones are referring to central bank.
This is a moot competition. And even though, if the law is not by our side, we have to manipulate law, Your Lordship.
Okay. No, but that, yeah, I understand the point, but I just wanted it to be very clear. I understand. Yes, of course, you have to make a persuasive argument to see whether, but that's just the position. You almost got me, because when I read the whole thing, I was a bit confused, but I had to go back again to ensure that I see an authority on that before I can decide. But I know that that's not the position, but I said, let me still check again. And I knew that, well, that's why I said deserving cases. I'm not saying that once there are two banks, it must be federal high court. You have to, the principle that subject matter must be considered is still the principle. That is the law. The subject matter, not only the parties. But when it comes to matters between banks, you have to be very careful. If the matter is not banker and customer relationship, because banker and customer relationship can exist between two banks.
Your Lordship, I still have one problem with respect to that particular section. The case of NDIC versus FMDN, Your Lordship.
Yes.
It was part of the decision of the court that in order to conclude, in order to determine the jurisdiction of the Federal High Court with respect to bank and another bank, the transaction between the banks must be examined. I think I cited a case where there was a conversion of. Thank you, my Lord. We perfectly understand you, and we rate your erudity, Your Lordship. Thank you.
All right. Any other observation? I will make sure that I provide a case on that, so that you see the situation where two banks will go to state high court. There is a case. One, mortgage bank versus something. There is a case on that where the dispute can come before the state high court. But when it comes to any other matter, apart from that, banker and customer relations, it cannot go there. But if you're interpreting the issue of agency, I agree with you. The issue of agency of federal government or federal government, the fact that it's an agency of federal government or the fact that federal government is a party, does not mean that you go straight to federal high court. Yes.
Your Lordship, if we were the counsels to the plaintiff, we can brilliantly argue that this bank, that particular sense bank, is an agency of the federal government. So, we are just okay with that, sir.
It may not be. You will not be able to succeed in that argument, because in fact I have an authority. I purposely got an authority on what an agency means. In fact, that authority that I have defined agency both by the provisions of Black's Law Dictionary, both by Wikipedia. They had to analyze what is an agency of federal government. So an incorporated bank, a bank that is incorporated under the Company and Line Matter, is a distinct body. Can never be agent of federal government. It cannot.
Oh, we understand you, sir. Thank you, Your Lordship.
So any other observation?
So, my Lord, how about agency by ratification? Is there nothing like that as contended by the defendant? Thank you very much.
There is agency by ratification. That's one of there are three types of agency now. Agency by ratification is one of them. Agency by Otistopel and one other one. Agency by Estopel, ratification, and agency by, I've forgotten the third one. So there is, but the issue before the court is not really whether he had authority to do so. The issue of ratification will come if we are alleging that they were not instructed by the federal government to rent the particular house. That means they acted outside the scope of the authority. That is when the issue of ratification will come in. But that's not our problem. Our problem is that supposed bank, while purportedly acting on behalf of an undisclosed principal, did not indicate that they were acting on behalf of anybody. They contracted as if they are the principal. The law is very trite and settled on that. When you contract as the principal, you are liable. Yes.
On that, sir, I humbly want to say that, when we are talking about a disclosed principal and an undisclosed principal, the law is that it is not an absolute requirement for the agent to expressly disclose his principal. Once the agent has present some facts to the plaintiff, to the third party, that a reasonable person may just infer from such facts that this person is acting on the capacity of an agent. The Lordship, it is in that particular statement of fact that there is a fungi house owned by the federal government, but currently being managed by Sense PLC. To me, I feel that it is clear from that hedge that particular Sense Bank is an agent. It's acting on the capacity of an agent for the federal, and also with respect to whether or not the party enters into that contract with his or her name. Your Lordship, I have a case, but I think the case is old, wherein the court held that the fact of the case goes like there was an agent, he disclosed to the third party that he was an agent actually, but he entered into such contract with his name. But the court held that, notwithstanding the fact that this agent entered into the contract with his or her name, the law is that he is still bound by the agency agreement, and therefore it can't be sued.
Okay. See, my response on that is this.
Okay.
When it comes to the contract between parties, must be looked into. Now, the reason why we have undisclosed principal is not that person was never ever mentioned. Okay, you can barely hear me.
I can hear you now.
Sorry. Can you hear me now?
Yes.
Yes, you can hear me now. I believe the principal, there was no idea, there was no sign. Okay, what I'm saying is that the contractual document is what should be looked into.
Okay.
Now let me give you an insight. Even when you are giving a power of attorney to defendant, case or to prosecute a case. No, let me not use prosecution. That is to go to court, let's say to sue somebody in a civil matter. It must be identified in the court process that you are suing on behalf of somebody. It must be there. Even when you are entering into a contract of sale of land and you are transferring interest in land and somebody gave you a power of attorney to act on his behalf, to sign all contractual documents, blah, blah, blah. When you are signing, it must be there. Lawful attorney of so person is there. So what we are looking at is the contractual document. If there is anything in the contractual document that shows that he was acting for another person, then the type of agency is called disclosed. But when there is nothing in the document to show that he was acting on behalf of somebody, it is called undisclosed. When we mean undisclosed, does not mean that there was no sign of him. He cannot come now. If there was no sign of him, privity of contract rule will hold him. Do you understand? So the issue of looking at the circumstances, that is what allows an undisclosed principal to even talk in the first place. Because even though that the document did not show that he was the principal, but there are other facts that can really show that that person was not ordinarily acting on behalf of himself. I don't know if you're getting it. Yeah, so that is the issue. When it comes undisclosed principal, does not mean that he was never ever mentioned or there was no reference to him at all. No. If there was no reference to him at all, the rule of privity will stop him from enforcing the contract. And that's why I said before that undisclosed principal is an exception to privity. What we are saying now is that somebody now comes up that I am the principal in this transaction. And then you are saying that, but we didn't know all this while now. In the document, there was nothing like that. The agent will not tell you that, but I told you now that this is the person. Then the confusion will not be, why did you not sign as if you are the person making the contract? It is right. You cannot be signing for yourself when you meant to sign for another person. It must be there. Even in administrative correspondence, check. When you are signing your papers and all that, you will discover that when somebody is signing on behalf of another, it must say, but there must be four. The persons, there must be four in that document. And so when it comes to disclosed principal rather, we must look at the document. So when there is nothing in the document that shows that it's a disclosed then it can suffice. Any other fact you are talking about, you are making reference to, can be used to ascertain whether we can even qualify him as an undisclosed principal. I think that's just it's about rules of agency. They are very clear. The truth is that I'm very appraised when it comes to agency. And because one of the courses I love so much was commercial law. And you know there is nothing in commercial law apart from agency, hire purchase, and what have you. Mainly agency and hire purchase. Although some school will add one other topic there. Some school will add, I think I've forgotten one other topic to commercial law there. Apart from sale of goods anyway. So that's it. I hope the position is clear. But if you still have your reservation, we are lawyers, so we are perfect. We decide to when we go to court to be settled there. So let there be. We've resolved the issue number one, the issue of arbitration. That one is clear. The second issue, which is on agency, whether it's an agent. I agreed. Remember, I agree with you that it's an agent. Yes, but because of the nature of this transaction, it can be sued. It can incur liability. You can check your textbooks, check your laws, and you see the exception. That is where an agent can incur liability. Check. You see when the circumstances where an agent can incur personal liability. You see that it's one of them. When he contracts as if he's the principal. That's one of them.
Thank you, my lord.
Remember, I'm not saying you cannot sue the federal government. Okay, connected now. Yes, Counsel. Can you hear me?
Yes, we are hearing you now.
Yes. Sorry. I think I'm back now. So I don't know if anybody wants to say something.
The counsel to the defender did not have anything to say again.
Okay. So the plaintiff?
No, my lord. We are very much satisfied. Thank you very much.
Okay. So how do you want it now? Should I declare the result right now? I'm listening. Should I declare the result now?
Yes, my lord.
No problem, my lord.
Okay, I can declare the result now.
Yes, my lord. Yes, my lord.
Yes, my lord.
Okay. With respect to I decided to formulate my own marking scheme, and I divided it into two. 50% for written brief and 50% for oral presentation. Are we together?
Yes, my lord, we are very much with you.
All right. Now, with respect to the written brief, I consider many issues, and I came up with this. The Plaintiff University of Benin. Are we together? The Plaintiff University of Benin.
Yes, my lord.
University of Benin. It's 40 over 50. 40 over 50. 40
Okay, my
percent.
Okay, my lord.
50. On the written brief. Now, as it applies to the University of Ilorin, initially, when I read their brief yesterday, I already awarded marks. But with their new brief, so I had to have a slight change on the initially awarded mark. So the defense, which is the University of Ilorin, they incurred liability of 2 marks. So on that note, if I deduct the 2 marks from their score, they will be having 33%. 33% on their written brief. I hope that's clear.
As a court proceedings, your lordship.
Yes, my lord, as court proceedings.
What they have is 35. Actually, before now, what they had was very, very low below that because of the nature of their brief. But I'm still going to point out that but maybe as time goes on. But so that is why because of the need this brief was better than initial brief. So that's why I had to increase their marks to that 33, which is supposed to be 35 if not for the 2 marks. Now, when it comes to oral presentation, just give me 3 minutes. I'll be with you so that I'll be able to put them together. Just 3 minutes. Let me put this course together with respect to the oral presentation.
Okay, my lord.
We'll just finish with
At the court, please.
Let me put them together so that I'll be able to give you respect.